This webinar will cover all things registered title and Form 3 applications. Today I will provide you with an overview of the Tailtear validation process. I will show you how to prepare and lodge an application for first registration in Form 3 using the prescribed form on the Land Direct website, and why relodging a previously rejected application correctly is important. I will set out best practice for lodging applications pertaining to registered titles. I will show you how to navigate to the relevant areas on our website and access the resources as well as mapping requirements. In September 2024, Tailtear created a validation unit whose role it is to review all applications against a checklist on lodgement. The checks are clerical in nature, but the unit does assess if the relevant fees, maps, supporting documents and prescribed forms have been lodged to facilitate registration. Where an officer first identifies an error with the documents and/or the fees lodged, the review stops, and the application is rejected, citing the first error that has arisen with the application. You should become familiar with our registration title and Form 3 checklist and guide, as it contains the relevant matters to be dealt with before lodging your application. Please engage with the checklist and ensure that your documentation is carefully proofread before lodgement. This will help avoid rejection at validation stage and also reduce the number of queries a case processing officer may need to raise once they read the application. All practitioners must consider the specific reason for rejection and fully review their application so that it is in order and complies with the checklist before relodging. Practitioners should note that the application may be rejected for a second time at validation stage if the error has not been satisfactorily addressed or if another error is identified after relodgement. Practitioners who have a Land Direct account can use the relodge facility on landdirect.ie. Applications that don't require mapping are processed in the validation unit once they pass the validation checks. Mapping applications are sent to the case processing units once they have passed the validation checks. Any application can be queried for minor clarifications if required, given 1 month to reply under Rule 183, and a further 10 days abandon warning notice. If no reply and unsatisfactory partial reply is received, the application will be abandoned and all documents returned to the lodging solicitor for review. The process map shows the workflow from receipt of the application through to completion. Please consult the application guidelines and checklists available on tailtear.ie to ensure that it is correct before relodgement, thereby avoiding possible rejections on the same application. To find the registered title and Form 3 checklist and guide, go to tailtear.ie. Click on Resources. From here, navigate to the registered title and Form 3 checklist and guide. This checklist has recently been enhanced to provide further context to practitioners on our requirements. The checklist and guide has various helpful links embedded within it: land registry rules, forms, practice directions, registration guides and checklists. Scroll down to expand on the various sections and get information on personal applicants, how to relodge a rejected application to ensure your fees are carried across to a relodged application. This guide also provides information on fees order, Form 17 and all forms for registered title and Form 3 applications, all of which I will go into in more detail during the webinar. This should be your go-to guide when lodging applications. I recommend having it open as you prepare every application for lodgement with us. Now we will look at first registration in Form 3. The benefits of registration in Form 3. Quicker turnaround times, it's faster. Cheaper fees. In many cases they are straightforward once you take the time needed to present your application properly. Here I will show you how to find the first registration in Form 3 practice direction on the tailtear.ie website. Click on Resources and navigate to the Legal Practice link. Select the first registration in Form 3 practice direction, where you find all the information you require before deciding if your application is suitable as a Form 3. Rules 19.3 and 19.4 of the Land Registration Rules set out the requirements for a Form 3 application. Please consult the Form 3 practice direction to see is a Form 3 the appropriate application type in this case. The most common areas to consider are set out here. The deed must be dated within 5 years of lodgement for Rule 19.3 cases. It must be conveyance assignment on sale, see Section 24.3 of the Registration of Title Act 1964, and the consideration must be less than the cut-off point for all Form 3 applications, which is €1 million, and where the solicitor has investigated the title to the property. When not to use a Form 3 application. It is incumbent on practitioners to consult our practice direction and ensure that your application does not fall into any of the criteria shown on this slide. If it does, then a Form 3 application is not appropriate, and you should consult our practice direction on first registration and other examiner cases available on the tailteann.ie website. All these are set out in the practice direction on our website. Now we will move on to the form itself. I'm going to take you through the prescribed Form 3 and highlight the sections you need to amend and complete as per the prescribed form. Please enter the county at the top of the form. At paragraph 1, the solicitor acting for the purchaser is the solicitor who investigated the title and should be identified here. The full name and address of the applicant is required. At paragraph 2, the details of the investigation of the property identified here by date of deed. This deed must be the most recent deed of conveyance, assignment or lease to the purchaser. At paragraph 3, certification, we convey that the fee simple or vest the leasee's interest in a lease, either by way of deed of a conveyance or assignment. If vesting a leasehold interest, full lease details should be set out in paragraph 3. I will show you detail in the next slide. This is the specific information that we need included in the paragraph 3 if the interest you are vesting in the deed of assignment is held under a lease. If the lease details are not included, this will generate a query. Moving on to paragraph 4, certification that nothing affects the property, but if there is a deed that affects the property, paragraph 3 or the current deed should include details of this deed where section 69 burdens are to be registered, for example mortgage or fee farm grant. Paragraphs 5, 6 and 7 are statements that you must certify to be true by signing the form. If you don't agree with any of these statements, this application isn't suitable as a Form 3 application. At paragraph 8, application, it's important to apply for the correct title here and any burdens required. What is the title of the property being sought? Is it absolute, good leasehold or qualified title? The most common burden would be a mortgage affecting the property, so please do not forget to insert the details here. The form must be signed by the solicitor certifying title. Certificates in Form 3 must be made and signed by the individual solicitor who has investigated the title and not by or in the name of the firm. The Form 3 procedure is not appropriate if the solicitor who makes the Form 3 has a beneficial interest in the property. If the dealing is rejected and relodged, please ensure that your Form 3 is dated within 1 month of the relodgement date. Also in relation to applying for Leasehold Form 3, where the underlying interest is unregistered freehold, the correct title to apply for is good leasehold, which is a marketable title. It is not necessary to apply for absolute title, but if you ask for absolute, you must include in paragraph 8 or in the cover letter that you have investigated all intermediate interests, and that as the solicitor certifying the title to us, that you have satisfied yourself that the title acquired to the leasehold property is an absolute title. Again, if this is not dealt with in your application when lodged, it will result in a query being raised. The main difference between first registration in Forms 1 and 2 and first registration in Forms 3 is that we rely on the Form 3 certificate and do not look behind the certification. Prior deeds or documents should not be lodged except in the following circumstances: where the leasehold interest is to be registered as a burden, there is a fee farm grant on title, the schedule of the current deed relies on a map attached to an earlier deed, the current deed shows evidence of a Section 69 burden in an earlier deed. If you are lodging prior title documents to support the registration as outlined, this needs to be explained in the cover letter. If any of the above are lodged and it's not apparent why, we will query the reason for lodging. I will walk you through the lodgement of a first registration in Form 3 leasehold interest and a charge using landdirect.ie. I will start by creating the Form 17, an important part of any application and must accompany all applications. If you are relodging a previously rejected application, please click on Yes when prompted. As this is a Form 3 application of unregistered land, we will select No Folio Required and select the county. From here, we will populate the application type, scroll down to select First Registration in Form 3 and Add to Application. If there is a charge lodged with this application, please scroll to find Charge lodged with First Registration and Add also, so that the system doesn't generate a fee requisition for this application type. Now we'll move on to the next field, Documents. Again, you scroll to select the documents and to add to the Documents tab. Here we need to select Deed of Assignment, Lease and Map. Populate the lodging party field and make sure to add reference. Select whether it is sole owner, joint tenants or tenants in common and enter the applicant details. Enter the name of the lender and select the type of charge. At this stage, you have added all the required application types and supporting documents and check your fees are correct. Preview the application and amend or confirm details at this stage. Please ensure you print a copy of the Form 17 before you exit Land Direct, and also be mindful that the Form 17 will expire 28 days after creation. I advise that you create your Form 17 only when ready to lodge the application. Please take time when creating the Form 17 to ensure all details are precisely set out, as applications created on our system using information that you input on the Form 17. Therefore, typographical errors in an applicant's name, for example, or an incorrect address in the state for service of notices, if not picked up by a case processing officer, may carry across to the folio on completion and will necessitate a post-completion query review. Finally, on the Form 17, ensure that the form is signed by a practicing solicitor and please date the form. The omission of proper signature and date leads to many rejections, and again, a review of the checklist and guide before lodging should remind you to sign and date the form. Please note, if you lodge a deed of charge under a subsequent or a separate application, you will be asked for fees, even if it is associated with the first registration application. Also, for relodgement of rejected applications, follow the instructions given in the register title and Form 3 checklist and guide. These are the most common errors that Form 3 applications are rejected for. Form 3 not signed and or dated. Not suitable as a Form 3 as the freehold is already registered. So please consider if your application should be a transfer of part, a full transfer, or a vesting cert application. Practice direction available on website. The maps not lodged, deeds affecting title not lodged, example, mortgage or deeds containing section 69 burdens. Paragraph 2 of the Form 3 quotes an earlier deed, i.e. not the current deed under which the applicant acquired their interest. The Form 3 does not conform to prescribed forms as per Land Registration Rules 2021. Application is based on transfer order, deed of exchange or assent. The application must be a conveyance or assignment for value. Prior to the completion, we will carry out continuation searches in respect of all Rule 19.3 cases, Judgment Office, Registry of Deeds and caution searches. We will perform these searches from the day before the date of the Form 3 certificate as you've certified up to this date. Where the applicant is a company's registration office in-house search will also be conducted to ensure the status of the applicant company has not altered. If the applicant is an ICAV, please lodge a central bank register search duly explained, dated and signed. These are some areas that generate queries, so if these could be clarified on lodgement, they will reduce queries and speed up completion. There may be some very valid reasons as to why the lodging party is not compliant with these areas, and they should address these issues in full in the cover letter with the application, as otherwise a query will be raised in relation to same. Now we will move on to talk about registered land applications. Most of what we covered in relation to the validation checks, preparing and lodging applications is applicable to all application types. I've shown you earlier how to navigate through the website by using the link provided, but you can also use the search function on the website and it will show all the information relating to your search. I have typed registered land as an example. I would advise before lodging any application that you visit our website at talcha.ie to find the relevant practice directions, prescribed forms and any other information you require. The most up-to-date prescribed forms should be used and adhered to, and only modified where the forms allow for such modification. Depending on the application type you want to register, the documents to be lodged will vary. Here I've chosen the most commonly lodged applications that we receive for already registered titles: a full or part transfer part, deed of charge and an application to release a charge. Please consult the relevant forms on the website to identify the form you require for your application. Please note if the incorrect application type is selected, this will cause fees to be incorrect. This commonly happens when a lodging party selects transfer rather than transfer part on the Form 17. It's important to ask yourself what type of transaction you want to register before you select the application type to ensure that you are identifying the most appropriate type for your registration needs. These are the sections of the Acts and the forms that are associated with transferring registered land. Please refer to the practice direction and forms section on our website for more information. These are also the sections and Acts that are in relation to charge and registered land. Again, all this information is available on our website. Section 62 of the 1964 Act refers to charges lodged for registration. Please note that Section 62(2) was amended by Section 8(3) of the 2009 Act by the deletion of "or an instrument in such other form as may appear to the authority to be sufficient to charge the land, provided that such instrument shall expressly charge or reserve out of the land the payment of the money secured." Basically, keep it simple. Stick to the prescribed forms when lodging and don't get creative with the wording. Rules 105 refers to all Forms 49 to 53 and 56 to 58. Forms 49, 51 and 52 are the most common forms of charge lodged. Again, the rules and the forms that are used for releases and discharges. Please refer to the cancellation of burdens practice direction on our website. The most common ones are 57A. This is a straightforward release where the owner of the charge is releasing. The 57B, the two most common ones would be where a judgment mortgage is statute barred and where rights and privileges for a person who has died are being cancelled. Also to note that in some cases the names and addresses of the beneficiaries of the burden may be required for notice. That address for notice should be a current address to allow for service of effective notice. This slide sets out the most common errors we encounter in registered title applications. Incorrect or no fees lodged. This relates to incorrect application type being selected. Application not relodged correctly. Deeds forms not dated or incorrectly dated in relation to transmissions. For example, assent not dated on or before the application. Deeds forms not executed correctly. For example, no witness to the seal of the company. All registered owners not identified joined in the deed. The full county and folio number omitted. And the operative clause defective. Another common rejection reason is that supporting documentation isn't lodged. Please ensure all required supporting documents are enclosed. For example, powers of attorney, probates, letters of administration, death certs, etc. Things to watch out for on the revenue certificate. The parties from and to must correspond to the registered owners and transferees. Unless the transfer is by a legal personal representative, if so, please explain in your cover letter if inserting the pair reps on the revenue cert. Also, if there is more than one person transferring and referred to on the deed, they must be identified on the stamp certificate. Please insert the folio numbers for the property. If folio number cannot be inserted, it can be added to the address line. If unregistered lands, for example a Form 3, the property description must match application details. Please note that revenue allows for the entry of up to 5 folios on the one stamp certificate. Now we'll move on to some of our mapping requirements and where to find them. The most important thing in relation to maps for our applications is that the engineer preparing your maps is familiar with our mapping guidelines and produces a land registry compliant map. Please note a number of new and updated appendices that came into effect of the 1st of July 2021. All are set out in detail in our registration guide and checklist link under resources on the website, of which there are 12 mapping guides. Mapping requirements for multi-storey developments are also available on our website. Here I will show you how to find the mapping guidelines which are available on our tolcha.ie website. Please go to Resources, Registration Guides and Checklists and scroll down until you come to all 12 mapping guides. All maps lodged must meet Tolcha Éireann's registration requirements and they must match the property description as set out in the applicant's deed or affidavit. For example, if in the deed is referred to as outlined in red and marked B, the map must correspond red and marked B. If it is outlined in blue and marked B, this will be rejected. Please ensure that you check that your application map boundaries are delineated in accordance with Tolcha Éireann survey detail. The picture on the left is the boundary is stepping away from survey detail. This will generate a query, especially for Form 3 registrations. Please be cautious where title boundaries don't match survey detail and we may need to serve notice. The picture on the right clearly identifies registered boundaries as adopted Tolcha Éireann survey detail. Also note that if the property is part of a multi-storey building, commonly referred to as an MSB, please check that you've lodged a location map as well as a floor plan for the unit being registered. On screen you will see some of the most common reasons why applications are rejected for maps. The map isn't Tailteann Éireann compliant, it's not to scale. Please refer to our MSB mapping requirements on our website for specifics on Tailteann Éireann requirements. Here I am showing you an example of a correct location map. The location map must show the outline footprint of the building in blue. Sufficient ITM coordinates information must be supplied for the location map and the floor plans. Check that the correct floor plan has been identified on the floor plan lodged. Things to note when preparing maps and relating them to the deeds. Be careful of the exclusion of balconies or car parking spaces referenced in the deed when preparing an application. To summarise, please engage with the Register Title and Form 3 checklist and guide and the mapping guides. Please use the most up-to-date forms available on our website for a seamless lodgement of application. All information you require to lodge an application is available on tailteann.ie under Resources. And remember the importance of filling out the Form 17 accurately. I hope that this presentation will assist you when preparing future applications.